morning, Your Honors.
Good morning.
My name is John Ryland from the Memphis Bar. I'd like to reserve 4 minutes of rebuttal time, please.
4 minutes. You may proceed.
Thank you, Your Honor. This case involves a divorce action that was tried in the Chancery Court of Dyer County, Tennessee in August of 2021. It involved a 34-year marriage and involved a situation where the parties had moved many times throughout the marriage in furtherance of the husband's military career. The main issues that are to address on appeal will be the issue of the division of marital debt and the marital estate and the alimony issues that were decided by the trial court. Some, at least, important background information is that what you had in this case was a situation where the wife initially worked during the marriage. She worked in jobs that paid no more than minimum wage, and she would have worked in jobs where she had to basically give up pursuing a career path because almost every other year the parties had to move in furtherance of the husband's military career. He rose up to the rank of colonel, and in 1993 my client stopped working by agreement of the parties to be a stay-at-home mother and to be a homemaker. In addition to that, she engaged in a lot of activities to further the husband's military career. In fact, the husband candidly acknowledged at trial that Ms. Perkins was a poster child for a military spouse, and he acknowledged that her efforts helped him go along and improve his career. He rose to the level of colonel, and when he retired from the military, that rank allowed as a springboard for him to get a lucrative employment position at Raytheon, making over $300,000 a year. He also, in addition to that, was receiving military pension benefits that were roughly about $6,120 net of taxes, and then he also received disability benefits that, as a result of the divorce, they would be about $1,400 per month, not taxable. So he had considerable income. Wife also had multiple health problems, and she testified about that extensively at trial. She suffers from mixed connective tissue disorder that she was diagnosed with just a few months before the trial. She had a condition called alopecia totalis, where she had lost all of her hair. She had suffered from depression. She had been through bouts of alcoholism, dealing with all of her health problems. She had lower back pain issues. She had rotator cuff problem issues. She had a condition called Morton's neuroma, Raynaud's syndrome, all of these things. The wife testified at trial that she could not work. And in the brief that has been filed by the husband, he claims, well, wife didn't put on sufficient proof to demonstrate that she was incapable of working. Number one, the case law in Tennessee is very clear that expert testimony is not required for somebody to demonstrate that they can't work. In the context of a workers' comp case, the court in Simpson versus Satterfield, and this is the Tennessee Supreme Court, noted, and I'm quoting, "It is clear that the testimony of an employee and other lay witnesses who first establish a proper factual foundation may be admitted on the issue of the employee's inability to work and may be sufficient to establish that fact without expert medical testimony." In this instance, wife gave extensive testimony about her inability to work and her health problems, and in fact, husband's counsel only asked maybe 2 or 3 questions about her health problems. And in fact, the expert witness that the husband had retained to testify about the issue of alimony, all of his calculations were predicated on a situation where the wife was not working. So I submit that that was essentially conceded almost at trial. There was no proof at all introduced to contradict my client's testimony on the subject.
Did the trial court make a finding about that?
Excuse me?
Did the trial court make a finding about
The trial court
your
did not
client's?
really expressly make a finding in that regard, but did not make any deduction for any employment income, which would, I submit, would be an implied finding that she was not capable of working, because there was no offset made whatsoever with respect to that. So what you have is, with respect to the issue of alimony, we had an expert witness that testified that Ms. Perkins needed $5,000 per month alimony in Futuro for 10 years. If she was responsible for the marital debts in her name, that figure would be $5,719, somewhere around that figure.
So let me make sure.
Of course.
That we're talking about the same thing. You're assuming that the trial court believed that your client was unable to work
Correct.
and found what it found, even with that in mind.
That's correct.
Okay.
Now, with respect to the alimony, the issue where the problem came into play are multifactorial. Number one, the trial court erroneously based my client's living expenses on the fact that she would be living in Dyersburg post-divorce, and that was not the testimony that my client gave. She went through detailed reasons why she was not going to be living there after the divorce. She had only moved to Dyersburg to be with her mother as she got out of a treatment facility and simply stayed there for the duration of the divorce case, but she intended to relocate to a metropolitan area, which is consistent with where the parties had lived during the marriage. So the trial court, we submit, erroneously based her expenses on living in Dyersburg. Then you get into this issue about the husband's attorney put on proof that, well, she could buy a house that was worth buy a house for $250,000 to $350,000, and that would be fine for her. The problem is that the trial court made specific findings that my client had suffered economic detriment as a result of the marriage, and she was economically disadvantaged. That automatically triggered the provisions of 36-5-121 Paren C, Paren 2, which says that you have to calculate, or the standard as far as the public policy of the state of Tennessee is when that has occurred, the disadvantaged spouse should be able to enjoy a standard of living reasonably comparable to the standard of living during the marriage or the post-divorce standard of living of the other party. The parties owned a house in Arizona right before they separated. They sold for $550,000. There's photographs of it in the record. It is an immaculate home. And in comparison, you have these houses that were not even remotely comparable to that house. And in fact, the husband's own experts admitted they had no idea whether or not those were comparable or not. They even admitted that the houses that they put forth in their exhibits in Dyersburg could have been trashed, could have been dated. They didn't know if they had the same amenities or anything. Yet, the trial judge made a finding that my client could buy a house in Dyersburg that was reasonably comparable to this house in Arizona for $250,000 to $350,000, when the only testimony at all in the record was that those houses in Dyersburg were significantly inferior to the house in Arizona. So the trial judge made this finding that was a predicate for his finding as far as the needs and the cost of housing, and there was no proof in the record to support that. That is a reversible error. That is an abuse of discretion when a judge makes a decision when there is no evidence to support that, and that's exactly what happened in this case.
Well, how did the trial judge make that finding then?
He said, I don't know how he made that finding because there was no evidence whatsoever in the record to support that finding. The only evidence in the record was that the houses that they put forth in their exhibit from Dyersburg, which were in the $250,000 to $350,000 range, were significantly inferior to the house in Arizona. And you can look.
Is it disputed that your client made it clear where she wanted to live, where she intended to live? Is there any dispute about that?
There is no doubt what she testified to at trial. Now, what they relied upon was in a deposition many months earlier before trial and prior to her being diagnosed with mixed connective tissue disorder. She talked about either wanting to live in Jackson or Dyersburg. The trial occurred like 8 months after her deposition. Her medical condition had changed and that sort of thing, and she offered extensive testimony about why she was not planning to live in Dyersburg after the divorce. That was very clear. There was no evidence that would show that she was going to remain in Dyersburg post-divorce.
Didn't she also have a property in Birmingham?
She did. She did. And that's where she lives today, but not in that house. But she did have a rental property there because the the party's children had been going to school down in Alabama. She was trying to restore a relationship with those children. The party's son was living there, and he was having some problems, and she was trying to help him through those problems. So yes, she did have a rental property in Birmingham, Alabama, Your Honor.
Did the trial court make a finding about where she was going to live?
The court made a finding that that since she was living in Dyersburg at the time of the trial, the court should base that as her home base, and did not consider what her actual intentions were as far as where she would be living post-divorce, which I submit was error. The trial judge also committed error by automatically reducing the alimony down from $4,000 a month. At the 53-month juncture, it goes automatically to $750. There was no rationale for that whatsoever.
I was going to ask that question. What's the basis of the reduction?
That's not in the
Anything
record at all. The trial judge didn't give any rationale for that at all, and we submit that that is another error that the trial court made. There was no reduction in my client's expenses at that point in time, and this gentleman has the ability to pay that regardless of whether he retired at age 62 or worked to normal retirement age at 67. And I'll address some other things on rebuttal now. Thank you.
Thank you.
May it please the Honorable Court, Judge Golden, Judge Stafford, Judge Armstrong, David Camp, and I represent the husband, Mr. Perkins. I do want to begin, and quite frankly, I'm trying to look through the brief submitted by the wife. I'm not sure about the Simpson case that has been cited in regards to that. I looked, I don't see where it was referenced in the brief, and I may have overlooked it, but not sure quite where to respond regarding that. But be that as it may, let me begin, if I may, from the property division aspect of it, then go into the alimony aspect of it. And I want to touch on that issue regarding the inability or purported inability of the wife to work at the alimony issue. In the division of property, which was raised by the wife on the first occasion, of course, there's been opposition provided by the husband in this case. It's very clear that the wife's walking out with substantial assets. Now, one of the things to have to understand, they kind of intertwine with each other between issue 1 and issue 2, is that Judge Childers, when he made his findings in determining about the issues of the standard of living of the parties, he made it very clear that they had always lived a very frugal life. Basically, they had always saved. It is very apparent from the asset division there. We're talking about $1.8 million worth of investment assets that were acquired. The wife, in fact, I think is walking out with around $265,000 in cash as a result of these parties' ability to put money back and to save money. And that's been part of how they've structured the way that they've lived their lives. So when we talk about how they've lived and where they've conducted themselves, it has always been to live, quite frankly, below what their means are, which is refreshing these days in a lot of the cases that I've seen regarding this. So I would submit to the court under the circumstances that without a doubt, the division of the assets have proven to be a huge benefit for the wife in this case, as an ability to be able to retain and sustain her standard of living, as the court had found here. Now, in addition to that, there was an issue raised. There's about $128,000 worth of basically what is identified as post-separation debt, which was attributed to the wife by the division, as Judge Childers handed out here, which did to some extent diminish back from what she received and what is considered to be gross assets in this case. But again, it has been identified by the judge that at the same time that she incurred $128,000 worth of debt, she had received approximately $183,000 worth of money and assets that she could use to sustain herself during that very brief period of time while this divorce was pending and during the post-separation period. So I would submit to the court that under the circumstances, the division of the assets and identified as the exhibit to the brief and required under the local rules of the Court of Appeals specifically lays out a very accurate division of assets in this case, and it spets out an equitable division of those assets in according to which the court made its findings. So we would submit that the trial court did not err whatsoever in the division of the assets, as at least been alluded to by the wife in this case. The alimony is a different issue. And as the court is well aware, there were two aspects taken. Mr. Perkins did not file this initial appeal. That was filed by the wife. He did, however, file a counter appeal, which is permitted under the rules, after, of course, he drafted his brief in response to the wife's position. One of the things that was found, and I direct it to the court's attention, is to page 25 of the husband's brief, is that the court made specific findings about standard of living, and that's something I think that's been alluded to, addressed, and talked about as it relates to the alimony award in this case. And we would submit to the court that the trial court erred when it even awarded any alimony in this instance. And that's because there are sufficient assets that have been accumulated during the marriage that would allow this woman to go ahead and support herself related to the investment income generated. But more importantly, it's the issue about her ability to work. Now, we're not obviously...
Is that disputed?
I'm sorry?
Is that disputed?
Well, apparently it is, from the perspective that the wife testified that she had no ability to work and then set forth all of these medical conditions and issues. But I point out to this court, the husband has documented through his discharge from the military 70% disability rating, yet he's still working. Now, he receives, in this case, an amount of money pursuant to that disability, and he gets that amount each month, close to about $1,500 a month, but of course it's not divisible as a marital asset. Judge Stafford asked the question about the issue about the reduction to $750 after 53 months. We find that to be somewhat interesting, perhaps that is characteristically close to half of what he would be receiving in that disability payment. I don't know that Judge Childers did it that way. I didn't try the case in this matter. Ms. Webb did, and I think did an exceptional job. But the point of the fact is that for that reason, the judge did decide 53 months worth of payments at $4,000 per month, and then reduced down to $750 a month from that point after. One of the points that had been extremely...
So you have no idea why it was reduced either?
I looked in the record, Your Honor, and I've tried to determine that. I can only speculate, which doesn't necessarily help the court any, and I don't want to do that unless the court asks me to. But the point of the fact is it just goes down at a stage when he's going to be about 65 years of age. He has a significant amount of disability issues himself, has been testified to, and also unchallenged. And so I don't know the answer to that, quite honestly. I don't know if the record really gives us any clarification on that. But we know retirement's an anticipatory event. We know it's going to happen. We know it represents an event that people can expect will happen.
But doesn't someone normally file a motion saying, I'm retiring and I want my alimony reduced?
I've seen that occur. It's modifiable. There's no question about that when those events do happen, if that's the case, if the court please. The court found that, I believe under the circumstances, that $4,000 a month for 53 months was more than sufficient to take care of whatever need there may be to last through that period of time. That seems to be prevalent through what the court's ruling is. And I think that structure, the court could have just as easily indicated, I suppose, that it would terminate after that period of time. But at this point, we can only go based on what the record shows us, which is the reduction that was anticipated to be done. One of the things I believe, too, if the court please, and this was testified to by Mr. Perkins during the trial, is that it had always been expected that he was going to retire at the age of 62. That was something he testified to. It's something he testified to that had been discussed with he and his wife. It was something that was well known among all of those, at least between the two parties in this case. And I think that was his intention and his plan. It fits with what he's trying to say because of the amount of assets that they acquired. The more you can put back to be able to have for your retirement years, the easier it would be for you to retire at that early age. His plan was, and still is, to retire at the age of 62. He clearly believes under the circumstances he's left her in sufficient enough good standing as far as her income is concerned, and the court found that she can survive on $75,000 per year based on what her expenses are and maintain that same, quote, comfortable lifestyle that they had grown accustomed to.
Did that factor in the debts as well that she was taking?
The factor in relation to the court making that determination?
Yes.
Yes, sir, because the court found that she was to basically assume that debt, understood how that division of assets would be, and then made the finding at that case that $75,000 per year would be more than sufficient. Understanding, too, she has $265,000 in cash that she ultimately got as part of this divorce division and this divorce settlement. Now, that leads to the point of the wife's alleged expenses being at over $10,000 per month. That number is beyond reason. The reality of it is that she testified and in fact still had lived in Dyer County for 2 years. If the court will recall, there was some procedural matters going on about dismissals being filed. There was, in fact, a divorce filed in Texas. That was challenged by the wife as not the proper jurisdiction. She pursued the matter to be filed in Dyer County. That's where she identified that she was living. She had a driver's license that put her in Dyer County. She was registered to vote in Dyer County. She graduated from Dyersburg High School in 1982. All of her ties were to Dyer County. Where Shelby County came from was absolutely a mystery.
Well, if she testified she was moving to Shelby County, what does that mean? And how
Well,
does the court take that?
Quite frankly, I don't know what it means. It means she's got a house valued over $500,000 that she wants to purchase down there. It means her expenses go up substantially. It means that it affects the outcome as far as what their argument is by inflating these expenses. So clearly you can pick a county that's going to be a lot more expensive to live in than Dyer County if you're trying to seek more alimony.
Well, did the court find her not to be credible?
I don't think the court found her not to be credible. I think the court found that under the circumstances, there was nothing there to support her anticipated move to Shelby County. She wasn't there. She hadn't established any residency there. And if anything, now what you're asking them to do is to try to anticipate an expense that's yet to be incurred by saying the house is going to be this amount of money, the rent's going to be this amount of money, and how much is involved while she still maintains a rental property in Birmingham. So I think it's just logical.
Is that the prerogative of the court to decide that?
In relation to what, sir? I'm sorry.
Well, when you've got direct testimony saying this is my intention.
Judge Stafford, I'm sorry. I'm trying to follow the
Okay.
question. I don't understand.
As I understand it, the wife testified, I intend to move to Shelby County.
Yes, sir.
These are the expenses I'll incur in Shelby County. The
Yes,
court
sir.
did not, I assume, I don't know whether you all disputed it or not, but I assume that the court found that to be credible testimony.
I don't know that the court found her not to be credible, but I don't think the court found that the evidence that was before it supported the anticipated expense of the move that she had yet to make, considering the fact that all of her ties had been and continue to be to Dyer County. And considering that it went to Birmingham related to staying there some in a rental property that she had, and she acquired that, I think in February of 21, a rental property in Birmingham that the son was living in.
So
there's,
essentially what the court did was, I assume, say, you may in fact move to Shelby County, but I'm only going to award you Dyer County expenses.
because under the circumstances, she can live wherever she wants to live, but all we have to go off of is where you've been living and where you've been staying. And I think that's what Judge Childers did. I don't think there was any statement per se where the judge says, I don't find that your comment that you're moving to Shelby County or that you're not a credible person. I think the court just simply said, we're not going to base payment of alimony on expenses that you say you're going to incur when there's no indication from anything you've done so far that says you're going to be there. And I would submit, if Your Honor please, that she can always come back to seek an increase if she chooses to do so in the event she ever moved to Shelby County.
Two questions, Mr.
Yes,
Kent.
sir.
First question is this: was it disputed that she would move to Shelby County?
Yes, sir. There was argument made that she had no ties. She was cross-examined extensively about her ties to Dyer County, and the proof presented by the expert realtor by the husband was about housing prices in Dyer County.
But the court made no finding about that other than to say, I'm only awarding you Dyer County expenses.
That's exactly what Judge Childers did. You're 100% correct, Judge, and I've identified on page 28 of the brief, and I think I'd cite to the Naylor case from 2016 out of the Court of Appeals, where it says questions involving reaching far into the future are best left to future judicial determination rather than crystal ball gazing. And I think that's the quote, and I put that quote in the brief because, again, that's what we're doing. We're crystal ball gazing, if you will, as to what may or may not be occurring should she elect to move to Dyer County. And as we now found through this morning, she hasn't moved to Shelby County. Now apparently she's moved to Birmingham, Alabama. So perhaps Judge Childers was correct in the manner in which that he was able to deduce that that would be the case. So I would
Let me
submit-
ask you, Mr. Kent.
Yes, sir.
Initially in your argument, you said they accumulated a marital estate of roughly 1.8 or $1.9 million.
That's correct.
And then later, you argued she's going to have at least 260-some thousand in cash.
Yes.
What are the other assets that she's receiving as a result of the division
Your
of
Honor,
marital estate?
for the court's information, if I can relay, it's the exhibit attached to the brief. The $265,000 was part of that, of her division. She ultimately received, I think the grand total, $921,789.91 in assets, which include, if the court pleases, and again, there were some divisions equally between the parties, but one half of a Charles Schwab account, a Raymond James account. There was an Invesco account that was split as well. There were various checking accounts and bank accounts that she got as well. And I'm talking to the tune in some instances of $160,000, $170,000 in one account, another $97,000 in another one, another Invesco account. She also received part of the 401k through the Rayathon assets that were acquired, or the pension that was acquired there. She's also receiving a monthly payment of $3,060 through the division of the military pension that she would get, and would get that for the remainder of her life if the court please. And then on top of that, a $265,000 cash payment that she received as well. That all totals up to around the $921,000 or so that she's received in assets in the division of the court please. And that was identified through Exhibit 7, which is attached to the husband's brief, if Your Honor please. In summation, I notice that my time is eventually running out. It is our position, if the court please, on behalf of Mr. Perkins, that there was no reason to even award alimony in this instance. There just simply isn't any basis to justify it. She receives a military pension, she receives investment allocations, and again, there's no proof she doesn't have the capability of being able to work, even if it's a minimal type work job that would allow her that opportunity to add to her income source until she's able to retire. I think she was 57 at the time of the divorce, of the court please. When attorney fees were asking the court to find that there's no basis to support this, the wife filed the appeal in this instance, the husband filed his response, and we asked the court to deny that as to the third issue. Thank you.
Thank you. You've got 4 minutes, Mr. Ryland.
Thank you, Your Honor. I'm going to try to deal with this in a bullet point fashion. With respect to the division of the marital debt issues, the husband argued in his brief that his argument was that this was post-separation debt, therefore it wasn't marital debt. That's completely contrary to the Supreme Court's decision in Alford versus Alford. It was marital debt. And what you had here, and why this is so grossly unfair as far as the ruling, because the ultimate net estate was divided 48% to the wife and 52% to the husband, even though the husband's going to have from his income and his resources $355,000 per year, whereas he's saying that the only thing that she should have to pay her expenses for are from the military pension benefit, which is about $3,060. That's how, with all due respect, how absurd his position is with respect to alimony, that he is saying that my client, after 34 years of marriage, after devoting everything to his career, and he is in a lucrative employment position in part because of her efforts, that he ought to get $355,000 a year, $29,000 a month, and live off that, and my client should live off $3,060. That is unconscionable to take that position. And that's one of the reasons that my client had to incur so much attorney fees and so forth in this case, because of the unreasonable positions that the husband took in this case. He was proposing that he get 57% of the net marital estate. He went out and paid off all the marital debts in his name before the trial, whereas she couldn't afford to do that. And Mr. Camp says, well, she had $183,000 during the 22-month period. Most of that was utilized in connection with the move and before temporary support was owed, but that was only 35% of husband's income during that time period. He had, though, their 65%. This argument that they were not living, they lived a frugal life. Look at the house that this gentleman is living in. There's photographs of it. He's living in about $600,000 5-bedroom house, immaculate. But he expects my client to live in a $250,000 house. This is just a situation where he wants to move on and enjoy all the spoils of the marriage and all of his income that she contributed to, and she can just take the scraps. That's not what the law is in this state. Their arguments about the alimony are largely predicated on their expert's testimony, Joe Enoch. And I invite Your Honor to look at Mr. Enoch's testimony because, number one, he had never done an alimony and needs analysis before, and he admitted when I cross-examined him that he didn't have any understanding about whether somebody should have the same standard of living they had during the marriage or the post-divorce standard of living the other. And he admitted on cross-examination that if she didn't receive any alimony, she wouldn't even be able to enjoy the standard of living that she did during the marriage or during the post-divorce standard of living the husband. So it demonstrated that his opinions were not even following the law. And furthermore, he admitted multiple errors in his calculations. All of his opinions about the wife's need for alimony were predicated on her living in Dyersburg and that she would open a $350,000 investment account and live off that. Well, he admitted on cross-examination that she wouldn't have any ability to do that. Plus, all of his calculations with respect to the return on that were all wrong, and he admitted all of that. And that's what they based their arguments on appeal, which his opinions were completely discredited. I think his appeal is frivolous, and I submit that my client shouldn't be required to dissipate the limited assets she received in pursuing this and would ask for award of attorney fees on appeal. Thank you, Your Honors.
Thank you, gentlemen. We will take this matter under advisement and attempt to get you an opinion resolving these issues at the earliest possible time.
Thank you, Judge.